Are you shocked when you hear about the number of innocent people who have spent years, even decades, in prisons for crimes they didn't commit? We'll talk about the Innocence Project right now on The Law Works.
From West Virginia Public Broadcasting.
Closed captioning for The Law Works is made possible by a grant from the Monongalia County Bar Association to support legal information and education for all West Virginians. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia.
The United States has the largest per capita rate of incarceration in the industrialized world, and not everyone in prison is guilty. My guest is West Virginia University law professor Valina Beatty. Professor Beatty, Valina, thank you.
Thank you for inviting me. It's lovely to be here.
What's the Innocence Project?
Well, the West Virginia Innocence Project in particular is a legal clinic at WVU College of Law. And it's students and faculty working together to find if people are wrongfully convicted in our state, in West Virginia. And once we can determine whether someone is wrongfully convicted, try and exonerate them, try and free them. The clinic, the project, also works on policy issues and reforming the criminal justice system to try to prevent wrongful convictions before they happen.
When we talk about wrongful convictions, we talk about people being in prison who are factually innocent, that kind of implies that the criminal justice system does not work correctly.
Well, vast majority of the time it does, and we do get the right person. But because of human error and also because of difficulties that we're growing to be more and more aware of, such as forensic fraud, such as eyewitness identification issues, all of these combine to occasionally cause someone who is innocent to go to prison, to make the wrong decision. And the Innocence Project works with prosecutors, works with law enforcement to try and get the right person, not just to free someone who's wrongfully in prison, but also to find the perpetrator who may still be free in the community.
You said human error, people make mistakes, but you said something that kind of makes my blood run cold when you say it. You said forensic fraud.
Yes.
What's forensic fraud?
Well, forensic fraud is particularly an issue, or has been an issue in West Virginia, and it's one of the reasons the Innocence Project has been so welcomed here in West Virginia. We've just begun, and yet we're already being welcomed into the criminal justice community because this state needs an Innocence Project. This state is familiar with what happens when there is forensic fraud. And to get to your question, forensic fraud can be you obtain evidence, hair evidence, or blood evidence, or DNA from a crime scene, and that's analyzed by someone in a lab, by a scientist. And unfortunately in West Virginia, there's someone very well known throughout the state now, infamous, Trooper Fred Zane. And Fred Zane was involved in falsifying results. He would falsify these results so that what he found at a crime scene would match to the defendant, and this led to wrongful convictions.
So he told prosecutors what they wanted to hear if they were trying to get a conviction. Prosecutors, the criminal justice system is an odd thing. We always talk about the presumption of innocence, that a defendant is presumed to be innocent until a judge or a jury says that they're not, says that they're guilty of the crime. But that presumption of innocence does not spread across the entire criminal justice system. The police do an investigation. They gather evidence. If the police didn't have a good faith belief that they had caught the right person, they shouldn't be arresting anybody, or at least not that person. Prosecutors, when the cases are brought to them, review the evidence. They often present it to a grand jury. They are required to have a belief in fact and in law that that person is guilty. So the police and the prosecutors don't presume anyone to be innocent. They presume that they're doing the right thing. It's the court, the jury, that presumes that the defendant is innocent. So sometimes you'll get a forensic examiner who simply believes he's doing the right thing by saying, well, I can't quite tell, but yeah, he's guilty, and sends those test results forward.
Yeah, and absolutely. As a former prosecutor, I particularly believe there needs to be more of a distinction between what the forensic examiner who's looking at the scientific evidence knows about the evidence and knows about the case. One of the problems, particularly with Fred Zane, was that he would know so much about the case, about who the defendant was and why that was the defendant, what the crime scene was, what the background to the findings in the case were. He would know all of that, and for him, it appeared that he consciously took that into consideration for his findings. But for other forensic examiners, they're not necessarily consciously taking that into consideration in their findings, but perhaps subconsciously on some level, they know they want to get the answer right. And the prosecutors believe the answer is this defendant, and if they can make that match, they're getting it right. And they're helping justice if they get it right.
I heard a prosecutor one time tell me, I too served as a prosecutor for a number of years, and another prosecutor, the elected prosecutor, said to me one time that he thought he was doing God's work. Well, God's work in the justice system is to make sure the outcome is just, that the outcome is fair, that the outcome is right. But this person, and I think Trooper Zane, believed that if somebody said that's the guilty person and he looked like he was guilty enough, that he was supposed to cooperate then in making sure that that person was convicted, not in being objective and doing the scientific analysis that is science, but in making sure the defendant gets convicted. And that's just not right.
And the scientific evidence can be very powerful. When you have an expert who gets on a stand and talks to a jury, they know this field, they have this knowledge that the rest of us only know vaguely, maybe through TV shows, through CSI. So here's an expert to talk about it. And when that expert says 100%, this matches to the defendant, that makes an impression that to a certain extent can't be challenged.
In fact, it's sometimes said now that juries expect to see scientific evidence, DNA and fingerprints and ballistic analysis and things like that, because they see it on TV so often. That must be an inherent part of the criminal process. We're talking about the Innocence Project. My guest is West Virginia University College of Law Professor Valina Beatty. I'm Dan Ringer, and this is The Law Works. So if someone believes that they have been wrongfully convicted, or that a person has been wrongfully convicted, how do you get involved? The Innocence Project.
The West Virginia Innocence Project actually relies quite a bit on the broader legal community in terms of referring cases. So in my past experience, and for other innocence projects, a number of cases have actually come from prosecutors, from defense attorneys, and also from judges, all of whom were involved in a case that just didn't feel right. It just didn't sit right.
Prosecutors refer cases to you?
Including prosecutors, yes. We've had that happen in my previous experience in Mississippi.
You've been doing this for a while in other states. You've just recently come to West Virginia.
I have, and I'm happy to be here.
And judges?
Oftentimes it's when the judge retires. The judge begins to reflect and reach out. And there's no harm in reaching out and alerting us to a case. We do our own thorough investigation of it. And if the person is guilty, and if there's evidence to show that they're guilty, or rather, if there's no evidence to show they're innocent, we can't take the case. We can't do anything on it. It's actually a very high burden to be able to overturn a conviction as it should be. There's a purpose behind our criminal justice system and to having convictions, but it's a difficult path to overturn that conviction. And that's, again, one of the reasons that the forensic science, the DNA evidence, is so important, because that can be new evidence, that can be newly tested and can show, DNA evidence truly can show 99% positive that it is not this person, it is not this individual, and in fact, it can match to someone else.
But if a prosecutor has uncomfortable feelings about the guilt of the defendant, doesn't the prosecutor have a duty to either not try the case or to continue to direct an investigation towards somebody else?
Correct, and I believe that many, if not all, prosecutors do truly believe in their cases when they're prosecuting them. But as they're in the office for a number of years and they perhaps learn more about the case, learn more about the community, learn about another perpetrator, that's when they start to see, oh, maybe there was a mistake done. It's not that they know at the time, but it's later. So for example, we had one case where the prosecutor was doing DNA testing for a perpetrator in another case. And then he decided to have it run against an old conviction that he had prosecuted, and he found actually it's this other perpetrator who committed the crime.
Well, similarly, don't judges have a duty when they're trying the case, if they come to the end of the case and they're really uncomfortable about the sufficiency of the evidence, to say, okay, there's not enough evidence here to sustain a conviction, I'm not going to allow you to get one?
That is true, but again, that is also a high bar. And once a jury has made a decision, it is a very difficult decision then for a judge to make, to overturn the jury's verdict, the jury's consideration of the case. I mean, it really is supposed to be in the jury box that the decision is made, whether the person is guilty or not.
And unfortunately, we don't know what goes on in the jury room when they deliberate a case. It's one of the great mysteries in the practice of law, and every lawyer will tell you that they would like to have an opportunity to sit on a jury, not necessarily to decide the guilt of someone, but to experience the process, the give and take, because sometimes there are negotiations, there are compromises made in the jury room. Well, it's not a matter, though, of just you saying, this case doesn't look like it was decided correctly, let's do it again, is it?
No, we have a thorough screening process. I'll simplify it down to two questions, though. One is, do we believe the person is innocent? Oftentimes we have someone write in who says, yes, I did this crime, but I don't deserve my sentence. That's not a case we take, obviously. Are there any indicators that this person could be innocent? But the second key question is there any evidence to prove it? And there's a number of people who write in and tell us that they're innocent, and there's just nothing to prove it one way or another, and we can't do anything about that. We really only focus on the cases where we have the evidence to show that this person did not commit the crime.
But that's not the same evidence that was used to convict them before. Because you and I could debate about the meaning of any particular bit of evidence,
right.
And that's what a criminal trial is.
Exactly, exactly. And that's already been done, and that's been ostensibly due process to put forward all the evidence that was available at the time. But so much can have happened in that span of time. So for example, a number of cases in the 1990s, there was evidence that could have been tested for serology, so
blood examination.
Exactly, but not necessarily for DNA. We've developed so much more expertise at testing DNA now that you need a much smaller sample size. And so 15, 20 years later, we actually can test that evidence to see 99%, was it this person or wasn't it?
Well, in DNA analysis, the scientist, whatever form it may be, often will get on the stand and say there is a 99.99999% probability that this is the right person. But if the test changes next week and becomes more accurate or examines some other aspect of that sample, that 99.999% probability can be seriously disrupted based on the new science as opposed to the old science.
Well, and I'm glad you brought that up because it raises another point, which is the National Academy of Sciences report in 2009, where the National Academy of Sciences was tasked by the government to investigate forensic sciences. And on this committee that investigated forensic sciences, it included judges, federal judges, prosecutors, defense attorneys, but also chemists, biologists, forensic scientists, people in academia, researchers. And that group of people took testimony and did their research and ultimately issued a report analyzing forensic sciences. And it said DNA is the one forensic science that you can say 99%, yes, it is this person. So many of the other ones, you'll have someone testify on the stand, an expert testify on the stand, and say, I looked at the hair, I compared the hair at the scene to the defendant, and it's 100% match. It's absolutely this person, and that's inaccurate. It's not correct, and it's beyond misleading. It's false.
Well, we can rely on ballistics tests and fingerprints, can't we?
Not as much as we once thought that we could, and definitely not to 100% degree. Again, part of the problem here is this testimony that there's no error rate. This is correct 100% of the time. And really, there's been no research to show whether or not there is an error rate, what the error rate is. We just know from other experiments that it's not always accurate, and that so much just depends on who is analyzing the evidence. If you have two different forensic analysis analyzing the same evidence, they can come to a different conclusion.
So often we've come to realize that these tests are absolutely spot on accurate until they're not. And it's when we find somebody or we re-examine the evidence and find that something was missed or that the old test wasn't quite right. I mean, at one point in time we thought the Earth was flat until some scientists went out and did some new tests and determined that it really wasn't flat. And that kind of re-examination continues to this date. We're talking about the Innocence Project. My guest is West Virginia University Law Professor Valina Beatty. I'm Dan Ringer, and this is The Law Works. If someone is imprisoned, or someone who knows someone who is imprisoned, and they have a true belief that that person is innocent and they want your help, how do they go about getting it?
I mentioned that we receive a number of cases that are referrals in the legal community. However, we also receive applications from inmates themselves. The application is available on our website, which is www.wvinnocenceproject.org. And it's also available by writing to us at the WVU College of Law. We do only accept applications that are filled out by the inmate, him or herself.
So mom can't write in and say, my son was wrongfully convicted.
If mom writes in, then we respond to her and we let her know that her child needs to write us directly. And we also write that inmate just a letter saying, we've received some information about your case. If you are interested in completing an application, please let us know. But it's very important that it's the inmate, him or herself, who's reaching out to us and who is making this claim of innocence. Not anyone else, but that person.
And they have to declare that they are innocent in that project.
That is one of the questions on the application we give. And sometimes people think that's ridiculous. You know, what do you mean? But often people will write in and they'll say, yes, I did it, but I was on drugs, so I wasn't in my right mind. Or yes, I did it, but I did it in self-defense. And those type of state of mind reasons, we don't take those cases. We only take actual innocence where you did not commit the crime.
Yours is not the only route to reviewing convictions. It's not a question of being convicted and then calling the Innocence Project. There are other steps through the criminal procedure that are available to inmates, people who have been convicted, to have their cases examined. One of those is an appeal after the conviction. Another is a petition for a writ of habeas corpus. Can you briefly describe the habeas corpus process for us?
Well, yes, and I'll happily also describe the appellate process because in West Virginia, we don't have an intermediary court. We only have the Supreme Court of Appeals. So it's a direct shot from the trial court to that supreme highest court. And until last year, that court did not have to necessarily listen to an appeal or make a ruling on an appeal. So quite literally, the trial court judge would have no oversight, no one to look at that case and review it again until a petitioner would file for habeas corpus, which is what you were describing later. So a petitioner files a direct appeal. Now the Supreme Court of Appeals does need to review it to some extent and create an opinion. That opinion, if it affirms the conviction, then the petitioner can petition for post-conviction relief, a habeas petition. And after that, that's in state court, and beyond that, then they can go on to federal court. So there are more steps, and that is actually the process that the Innocence Project uses. We file habeas petitions, usually based on newly discovered evidence.
The traditional habeas petition that would be filed on behalf of a prisoner says, in essence, I was denied my constitutional right to a fair trial because, and there can be a variety of reasons. I had a bad lawyer. It's ineffective representation of counsel.
Correct.
It can be that the judge wasn't objective in the rulings or something like that. But generally, it has to be a constitutional level deprivation. The Innocence Project, you kind of assume that those things were looked at, don't you? And then you look at scientific analysis of the evidence?
Correct. In terms of forensic fraud, there may be an instance where trial counsel was ineffective because they didn't bring their own expert, or they had asked the court for funds for an expert and the court had denied the funds for an expert. So there can be a situation where the state was able to have someone like Fred Zane testify and say, we found these results, it's 100% the defendant, and it's not, and it's false. And unfortunately, there hasn't been anyone else to test that evidence at trial. So you can make that claim as well, but really you're accurate, that you're correct, that we are bringing claims based on new evidence, new information that is discovered that creates a bigger picture of what happened.
We discussed it slightly at the beginning of the program. The tests that we relied on for decades, or the evidence that we relied on for decades, eyewitness testimony, for example, we just all accepted that as being correct. Everybody thought, well, if the scientist says that's right, if the eyewitness had a clear view and observed it and says that's the person, the justice system was kind of predisposed to accepting those things as correct. In West Virginia, we found out that that wasn't necessarily the case when an attorney named Lonnie Simmons, who practices in Charleston, didn't simply accept the West Virginia State Police Forensics Laboratory examination in a particular case, and he said, I want to have my own expert check this. His expert checked it, and we found out that Fred Zane had been lying.
Exactly, and that started the whole investigation into the lab and into Fred Zane's previous work, absolutely. But you bring up a point about victims and witnesses identifying someone and mistaken eyewitness identification. Almost 75% of the 300 people who were exonerated and have been exonerated in the United States, almost 75% of them were convicted in part based on a mistaken ID, which means that the witness or the victim picked the wrong person out of a lineup. And we can all think, how could that possibly happen? And this is part of the reason the Innocence Project works with victims advocacy groups as well. Because when there's an exoneration, often it's the victim or the victim's family who feels the most confused or betrayed by the criminal justice process, that they could have mistakenly picked the wrong person, that they were part of this. Jennifer Thompson and Ronald Cotton have written a book called Picking Cotton, where she identified Ronald Cotton out of a lineup and said, absolutely, this is the person who assaulted her. And then when the DNA evidence came back, she couldn't hardly believe it. And that's why there's been more and more research examining how best to do an eyewitness identification. That research has found there are simple steps that can be taken to make that identification more reliable. And as professionals that police are, to further professionalize their work. And I'll briefly tell you those 2 steps.
Okay, we just have a few seconds left.
Oh, okay. One is that you show the picture one at a time of the lineup photos, and that way the witness is examining them against her memory. The second is you have blind showing, so the officer doesn't know what photo the witness is looking at and can't subconsciously influence the witness's decision.
And the story continues to develop. Professor Valina Beatty, thank you very much for being with us.
My pleasure, thank you.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening. If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a DVD of this show for classroom use, send us an email to thelawworks@comcast.net or visit us on Facebook. On the Law Works website at thelawworks.org, you'll find a listing of recent The Law Works programs, additional information about this show's topic, and video of this and recent shows. You can also find the Law Works programs on YouTube and iTunes.
The Law Works is produced in cooperation with the Office of the West Virginia Attorney General, the West Virginia Bar Foundation, the Mountain State Bar, the Monongalia County Bar Association, and the West Virginia University College of Law. The Law Works is made possible by major grants from the Office of the West Virginia Attorney General and from Software Systems Incorporated, a West Virginia company established in 1975 which provides high-end support services, programming, and consulting for county government AS400 mid-range computer systems, as well as PC-based systems, and by a grant from the West Virginia Bar Foundation. The West Virginia Bar Foundation, the philanthropic organization for West Virginia's legal profession and justice system, promoting public knowledge of the law in West Virginia. Additional support for the Law Works is provided by the West Virginia Supreme Court of Appeals.
From West Virginia Public Broadcasting.